it's very complicated. He's a professor at a leading university in Argentina, and he is a government official and a judge, something in between. It would take us another half hour to explain it to Germans. So perhaps Argentina, it's more the French system in this respect. And it has a lot to do with finance also, finance control.
Yeah, but no, we have judicial control, and it's the work is complicated to explain in the ordinary system.
Yeah, so
maybe the prosecutors was the most precisely idea.
I see. So, but we need the remaining 20, 30 minutes for your report and also explanation of your profession.
Well, first of all, I want to say many thanks for Roland Ismer, the authority of Erlangen University, and Susanna and Simona for your kind help. It's very good to see you there. And especially for my friend Klaus for his invitation, the accommodation and all the program, all what you prepare for us, it's perfect, so congratulations. I'm going to talk about foreign investments in Argentina, the close of the B.I.T. During the 90s, Argentina signed with various countries several treaties on the promotion and mutual protection of investments. These bilateral investment treaties, in later B.I.T. or B.I.T., have fulfilled a role to validate the confidence of foreign investors as long as they have tried to assure through various means the protection of investments in Argentina. In this study, we will analyze the most relevant aspects of the subscribed B.I.T. with Germany and how were planned in practice some of its provisions. On the other hand, we take an overview of the jurisprudence, both national and international, to serve as coordinate that allow us to predict trends in the protection of foreign investments. In this task, we will analyze the different causes that have led investors to bring their disputes before at the international arbitral tribunals and propose an alternative to the settlement of disputes. In April 1991, in the city of Bonn, the Argentine Republic signed an agreement on the promotion and protection of investments, which consists of 12 articles and an additional protocol with the Federal Republic of Germany. This agreement was approved by the Congress of the Argentine nation on June 10th in 1992. This treaty, as all B.I.Ts, set the protection of investments made by investor of a state party in other state party. In this sense, the B.I.T. defines the term investments in a wide and declarative way, thus establishing that it is all kinds of assets defined in accordance with the laws and regulations of the contracting party in whose territory the investment has carried out in accordance with this treaty, establishing also an unlimited list of definition of the term investments. Before addressing the central issue of this study, it is relevant to mention, also briefly, the main clauses that contains this treaty. In this regard, as well as forecast relation to the compensation for damages and prejudice, defenses against nationalization or expropriation, and the system of the repatriation of profits and investments, the agreement concerns the following. Fair and equitable treatment. Establishing the clause known as fair and equitable treatment, which constitutes the general standard of care that has been developed under the custom of international law for investments made by each of the state party foreign investors in the receiving state party of investment. as long as there is not a precise definition of the content of this basic standard. Its inclusion in the B.I.T. serves not only as a basic standard, but also as an auxiliary element for the interpretation of a specific provision of such treaties and possible situations not provided in them. Within this clause also often include as element of fair and equitable treatment, among others, the principle of non-discrimination, the international minimum standard, and the duty of protection of foreign ownership by the resident country. National treatment and most favored nation clause. By virtue of the national treatment clause, foreign investors should receive equal treatment as national of the host country for investments. But in addition, this B.I.T. includes the most favored nation clause, thus establishes that in all matters government, this treatment will not be less favored than that guaranteed by each party to investments in its territory by a third country investors. Nevertheless, the MFN clause has its exceptions in Article 3.3, where its limits and exceptions can be forecast, taking into account the membership of states party to treaties of customs union of free trade, common market. It is thus that otherwise the simple implementation of such clauses would entail the automatic extension of the benefits agreed to members of those forms of intervention. In addition, the limitation referred above, exit arbitrary jurisprudence has also limited through interpretation the scope of MFN clause as explained in the next chapter. Settlement of disputes. None of above-mentioned clauses could be doubled without an adequate system of settlement of dispute to ensure investors the early settlement of an eventual conflict derived from an investment protected by the B.I.T. Thus, states with the signing of this treaty have been made available to investor systems of dispute settlement to ensure them that those will be quickly settled by an independent and impartial tribunal. This is one of the cornerstones of the protection of investments and the purpose first by the B.I.T. In the case of the B.I.T. under review, dispute settlement system is provided in Article 10. The agreement provides the possibility that dispute can be settled by local courts or by an independent arbitration tribunal. Starting from zero and according to the wording of clauses, it is warned that is mandatory rather than optional. This solution is at odds with adopted in other B.I.T., the one subscribed with the USA, laying down a procedure of choice of paths, in whose virtue the investor, after having complied with the notification of the dispute to the state recipient of investment and expired with friendly negotiations, can submit the dispute according to its choice to the local courts, which implies the resignation of the arbitral jurisdiction or directly to arbitration. In the case of the B.I.T. under study, it is said, firstly, that the parties should try to arrive to a solution through friendly consultations. Then is settled that if these consultations do not provide a solution, which indicates the inescapable prerequisite condition, within a period of 6 months, the dispute shall be submitted to the competent courts of contracting party in whose territory the investment was situated. It is important to note the term will be used by the standard, which is obviously not recognizing an option. Rather, an attentive, prominent escalation points out the only way possible to follow. This is the case without prejudice to that I will point out later. Such a conclusion is reinforced if we take into account that the B.I.T. establishes that the controversy may be taken to an international arbitral tribunal, when there is not a determination of the found after 18 months counted from the beginning of the proceedings, provide for in paragraph 2 of this article, or when there is such a decision but the dispute continues between the parties. However, the possibility of going to the arbitral tribunal, if it has not been resolved, the dispute already raised, will entail the withdrawal of the proceedings in courts. This being so, it seems by agreement these clauses, the local rules of procedure have not been evaluated with precision, so it is necessary to make a brief summary about its most important aspects. In other words, and in the case of investments made in Argentina, what means in particular for the foreign investor previously subject Argentine courts controversy, and what consequence can be derived from the withdrawal of the legal proceedings in courts. However, from review the Argentinian jurisprudence linked to this issue, it came to our attention that local courts have hardly been called to intervene in disputes that arose between government and foreign investors, which turned out to be the most affected by drastic change in legal developments during the first months of 2002 as a result of the abandonment of the convertibility system. All this issue we're talking about Santiago, Carrillo, también Coronel, and the rest of you. Indeed, in the case of public services, the changes were significant and involved an abandonment of the prices in dollars involved in the contracts of concession of license, the compulsory conversion of values in dollar rates at the exchange rate before the devaluation, the rate of 1 peso for $1, the prohibition to restoring rates in dollars, the imposition of a new standard of calculating rates, who led for the first time clear political objectives such as the redistribution of income, the obligation to continue providing services without any decline in its quality, and the obligation to renegotiate the terms and conditions of existing agreements. However, and as we have previously shown, the Argentine courts have mostly remained silent. They have not granted precautionary measures in favor of the public service companies, or is registered no decision granting compensation or invalid government measure which has been damaged to the public service company. On the contrary, it has excised profuse activity of international arbitral tribunals. If one takes into account that the courts can act only at the request of an interested party, and if it stands on obligation forecast in the B.I.T. by previously submitting the dispute to the local competent courts, two questions emerge clearly. Why investors have not requested the intervention of the local Argentine courts? And how have been able to submit disputes directly before at the international arbitral tribunals without having previously submitted the issue to the courts of Argentina, which was where was located the investment? The silence of the Argentine courts, its possible causes. In a legal system which seeks to conform to the principles of the rule of law, private parties damaged by the state action normally seek compensation at the local courts. Nevertheless, they can be deterred by different reasons. Maybe can consider that local laws do not provide sufficient protection, may think that the courts lack independence from the government, or have prejudices about certain private parties. Access to the courts can be very expensive. The time required to obtain an effective remedy may be too long, and other legal redress alternatives